I'm pleased to welcome to the program my final guest for this morning's program, funny enough. She's a junior research fellow at the Sir Arthur Lewis Institute of Social and Economic Studies. This morning we will be discussing whether or not disabled are at a disadvantage in the sense that the Equal Opportunities Act, well, is it equal enough? And I'm pleased to welcome Dr. Bephyer Parey. Good morning, Dr. Parey.
Hi, good morning. Thank you for having me.
Well, thank you for joining me. I'll start by asking you, does the existing legislative framework here in Trinidad and Tobago, does it actually support equal opportunities as well as fundamental human rights for the disabled?
So thanks for the question. So that's a double-barrel question, right? So I have to take it
Sure.
in part. When we think about equal opportunity, there are different ways someone can conceptualize equal opportunity. And so if you look at the dictionary meaning, in some cases, it does mean freedom from discrimination. And so the Equal Opportunity Act does promote anti-discrimination, right? So in that sense, it may be promoting equal opportunity. But when you think about the system under which we're operating into society, meaning capitalism and the guiding principles of capitalism, that's competition. There's another definition that you can actually give to equal opportunity, and that means the chance to compete. And so if we're operating from that definition, definitely no, the Equal Opportunity Act does not promote the opportunity or the chance for persons to compete. It's a little more complex than that as well, right? Something like primary school education, secondary school education, adequate healthcare, those are fundamental human rights. And someone should not have to compete for those things. And so to answer the second part of the question, it definitely does not promote fundamental human rights. We all are aware that primary and secondary school education is often guaranteed through universal mandates, and therefore there's a clash between the definition of equal opportunity as well as the achievement of those fundamental human rights.
So whilst offensive behavior and discrimination is addressed by the Act, is there, in terms of disabilities, is it that disabled people are at a disadvantage in the context of the Act? Can we just clarify that?
In a number of ways. So, for example, the offensive behavior, there is a distinction between formal discrimination, which relates to organizational policies and practices, and interpersonal or informal discrimination, which relates to inappropriate jokes, rumors, and other negative verbal or non-verbal behavior. And so with regards to the informal discrimination, the Equal Opportunity Act does protect against it for certain status categories, but not for disability.
Now, in terms of the most common complaints lodged by people with disabilities, is there any information with regards to whether or not it's majority informal discrimination or formal discrimination?
It's both. And so in the case of disability, obviously for persons who are seeking redress with regards to informal discrimination, unfortunately the Act does not support redress for those issues. But just generally from the cases, there were three common things that persons were asking for. And when it came to the informal discrimination, one of the things that complainants were asking for was an apology for the emotional distress or the psychological harm that they experienced. And of course, the Act does not cover that by disability.
And what about the facilities in place to redress such complaints put forward by those who are disabled? Is there enough in terms of the institutional capacity to deal with these complaints?
In terms of the EOC capacity?
Yes.
So that's a good question. It wasn't part of my research, but from my personal interaction with persons within the organization, I do not think they have enough human resources and perhaps other resources to adequately address the complaints. But part of it has to do with the law itself, right? Because the law is promoting anti-discrimination, but anti-discrimination does not guarantee that persons with disabilities will achieve their fundamental human rights and well-being. So I think it's two things, right? Yes, the EOC perhaps needs to have an expanded capacity to really operationalize the act, but I think also the act itself is limited, and therefore changes within the act is needed.
But
Are needed.
the act itself, though it is limited, in terms of the operationalization of the act, is that fully enforced even in its current form?
So that's a very good question. I think it is. Because, and you see it from the complaints and the way the EOC addresses those complaints, they always refer it back to the definition of disability. So in terms of applying what the act means, that is done 100%. And so again, the challenges with the act would be the operationalization of the term discrimination, right? And what discrimination means. And essentially discrimination, according to the act, you have to take into consideration two persons and compare those two persons in circumstances that are not materially different from each other. And you're essentially comparing whether one person is treated less favorably than the other. And so operating from that definition definitely is not going to support equal opportunity for persons. And so let me give you an example to contextualize that. So if a company is accustomed to laying off their workers once they become disabled, it means, and this has been going on for some years, and then someone in 2023 becomes disabled on the job, their response, although there are so many discourses speaking about alternative job arrangements and so forth, the company's response is going to be to lay off that person. And of course, not all companies would have those responses, right? But the general response would be for the company to lay off the person. And according to the definition of discrimination, when you take into consideration that person's circumstance or that person's outcome in the circumstance that they are in and compare it to other persons who were in a similar circumstance, then you would say that no discrimination took place, right? Everybody is being treated in the same way. According to the definition of discrimination. I hope that adds some clarification to the whole concept of discrimination and equal opportunity.
Well, it certainly does because, and please correct me if I'm wrong, it just basically boils down to one thing. Anti-discrimination does not necessarily mean equal opportunity. And,
exactly.
And that is, I'm glad this issue has been raised. Now, in terms of the complaints that have been lodged, in terms of closing these cases, in terms of actually dealing with them, I know we already spoke about the institutional capacity, but in terms of actually dealing with cases, are these cases, those that are actually heard and those that are actually investigated, are they closed easily or are there various challenges or obstacles in actually trying to deal with such complaints?
So let me just say there is an attempt to investigate all the cases, right? Before it can reach the investigation process, though, depending on how much information the complainant gives, the EOC does reach out to them to get more information, to clarify information that they may have. So that's the first step, right? And so in some cases, actually, perhaps in one case, there was someone who never got back to the EOC. With information that they were requesting, and so in that case, the complaint was closed, right? The other issues with regards to complaints being closed would be the time window, right? According to the Act, a person who is lodging a complaint about discrimination should do so within a 6-month window, and of course, in following through with what the Act says, cases that were lodged or complaints that were lodged after the 6-month window, they were closed, right? Because that's essentially what the Act says. So when I say there are adjustments to be made to the Act, that is perhaps one of them, right? And so let me just add in there, it was 105 complaints. You're reading these complaints as a researcher, as a human being, and just reading it as a human being. They were very traumatizing experiences that were written in those documents. And so me as a researcher, was very traumatized, just engaging with these files. And so I can imagine that it was very traumatizing for these persons who were in the experience. And sometimes, perhaps, when you're experiencing trauma, you perhaps need more than 6 months to process what's happening and realize, oh, I need to do something about this. So that 6-month window definitely needs to be expanded. Or perhaps the circumstances, the regarding exception to that 6-month window need to be explicit within the Act. What do you consider as exceptional circumstances? There were also cases where there was involvement by other external agencies. So it is possible to lodge a complaint with the EOC and also lodge it with another organization. But what was found from analyzing the files is that the EOC did not get involved if the complaint was lodged with another organization, right? And so that there is there's some conflict there as to how involved the EOC should get when there are other organizations who might be responsible for addressing the issue. And then in a lot of cases, it's actually 53% of the closed cases. According to the Act, following the definition of discrimination in the Act, the conclusion was that discrimination did not take place. And therein lies the issues, because that's where you would find a lot of issues of maladministration, malice in the workplace and in other organizations that is preventing persons with disabilities from accessing the service or accessing the type of work environment that they need to operate in. So again, the definition of discrimination needs some needs to be changed, but specifically, offensive behavior within the Act should cover disability as well. And of course, there were a few complaints that were closed because they fell outside the jurisdiction of the EOC. And again, it comes back down to maladministration and malice and poor organizational procedures. And then as well, there were some complainants who were requesting for their case to be closed. So in some cases, persons would have, their complaints would have been referred to conciliation or to the tribunal, where they asked for it to be closed. And they had a very good chance of having, of receiving some sort of redress, right? What shape that redress takes is another story, right? But they had a very good chance because they had documentation in terms of showing that discrimination took place. What was challenging for these persons is that, one, the person who was referred, the complainant was referred to conciliation, they were not seeking financial compensation. They were essentially seeking some sort of change, which perhaps may not have come out of the conciliation process. And then there was another complainant. She actually got a medical condition on the job, and she was having a difficult time just maintaining her health, and therefore she could not finance the case going to the tribunal. And so just to say, when a case is referred to the tribunal, it's the complainant who's expected to cover the cost for the legal procedures and whatnot. And so
that's a very important point that you've just raised there.
Yeah. It's very unfortunate, and I say this because so I've been researching disability for some years now, and one of the things that's emerging in my own work, and then something that's emerging in the general literature globally, is that persons with disabilities experience extra costs when they're accessing services. And so, like, let me just give an example to contextualize it, right? So someone who is accessing healthcare, like you and I accessing healthcare, we might jump in our car, be able to drive to the hospital, or if we have to use higher transportation, we were able to do that very easily, take public transportation and go there. But someone with a disability may actually have to hire transportation. Yeah. And while it might cost like $6 or $12 Trinidad dollars to reach the hospital, that person might have to pay like $50, perhaps more, just to get to the hospital. And then obviously there's the trip back home, right?
So even the cost of lodging a complaint and the cost of it going to the tribunal Is that really a costly adventure? Like, is it something that actually even restricts the ability for people with disabilities to try and have their voices heard and their complaints actually seen to?
Right. So that's a very interesting question. And so it's something my colleagues and I have had to think about recently. And so when you think about the EOC process in terms of filing a complaint, it is possible to file a complaint via email, via the website, but this is in person as well, and you can post it as well. But this is assuming that persons actually have the finances to access the online website, to send an email, or to even post it, or even to appear in person, right? It's a big assumption to assume that persons would be able to cover the costs associated with these things, right? We are very much aware that not everybody in Trinidad and Tobago has Wi-Fi, that they may not be able to afford Wi-Fi. So that is something that definitely needs to be taken into consideration when, with the complaint process. The other thing is that we are also assuming that persons are literate. Persons with disabilities historically have been excluded from many aspects of society, including education. And so not all persons with disabilities have formal basic education and may not be able to complete that form on their own. And I think even if the message comes across in terms of, oh, you can file a complaint with the EOC, to seek redress for whatever you're experiencing, for them, how does that translate into actually carrying out
Yes.
lodging a complaint is another story.
Do
all
you,
of these things need to be taken into consideration.
Beyond that, I also know that you mentioned that there are those who actually decided not to go further with their complaints. They've actually withdrew their complaints. Is there that sense of further discrimination with going through this process? Are we fearful that even when we're trying to have these situations sorted out, the results of that can lead to further discrimination?
So yes, another very interesting question. So other than the closed complaints and it being there being a request by the complainant to close the complaints, there were complaints that were withdrawn, right? This was actually about 46% of those withdrawn cases. And so let me just give another example so you understand while I answer the question. So there was a situation where a parent was trying to enroll their child into primary school, and they were essentially rejected from 3 primary schools. And then the parents had lodged a complaint and eventually withdrew the complaint because she went to a 4th primary school who took in the child. And now, so she got what she wanted, essentially, right? Enrollment for the child. But what we do not know, and essentially what your question is asking, we do not know if this child has access to education within the education system, right? I'm also doing another piece of research with regards to children who didn't have Wi-Fi or devices during the pandemic. And one of the things emerging from that research is that there are teachers who are discriminatory. And so this is students who don't have a disability, and there is some discrimination there. So I do believe that perhaps discrimination at the teacher level is happening within the primary and secondary school system as well, that may be hindering children with disabilities from getting quality education within Trinidad and Tobago.
Well, I'm glad we've had this conversation and we've gone to the extent that we have, because not only have we realized that the existing legislative framework, it needs to be amended, because currently, arguably, there is weak legislation. It does not cover all grounds. Furthermore, beyond that, just bad administration, as you mentioned, and the example that you just gave, even within the school setting, given the fact that there is weak legislation, certainly does not help the case at all. But Dr. Bephyer Parey, I want to thank you very much once more for joining me on the program this morning. And I appreciate your time, and I appreciate you sharing this information based on your research with us. So thank you very much for that.
Great. Thank you for having me.
All the very best.